Mr.
Yeah,
Mohan
yes.
Gopal.
Yes, sir. Yes, sir.
What you say is absolutely right. Right.
Yes, sir. Yes, sir.
Now, our difficulty in courts is
Yes, sir.
right from the trial court stage. Right.
Yes, sir.
The police has the power to investigate.
Yes,
Right.
sir.
Now, when they find materials, right, and materials point to the, the accused having committed the offense, right?
Yes, sir.
The trial court is helpless,
Yes, sir.
right? The trial court
sir.
at that stage, at time of cognizance of framing charge, right?
Yes.
At that stage, the trial court is helpless because there are materials. 3 or 4 witnesses have said something. I'll
Yes,
give you a concrete example, right?
Yes, sir.
You remember that Arushi Talwar case?
Yes, sir.
The Arushi Talwar case, the CBI filed a closure report. And the reasoning they gave is that there is no direct evidence, no eyewitness, right? And since this is a case where the prosecution has to be based on circumstantial evidence, we find gaps in circumstantial evidence. So the chain of circumstances don't lead to one hypothesis, namely conviction. Right? Therefore, they submit a closure report. Very fair. And the magistrate, being influenced by the media and the fear of the media, opened up. Right. Opened up the closure report. And he cited some materials. The matter traveled in revision before the High Court, then came to Supreme Court. Supreme Court, initially Justice Ganguly and Justice Kher were there. They dismissed the revision of Nupur Talwar, right? And they said, we can't. Then review was filed. And, because Justice Ganguly had retired, I had to take up the review as the presiding judge, Justice Kher. And he heard the matter. And I asked Justice Kher, what is to be done? Because in my view, the whole thing is doubtful. The parents are not involved. Right? They may be involved, may not be involved. But the CBI is the very first instance. They were very right. Because the chain of circumstances were not leading to one hypothesis, namely conviction. Right? Therefore, the magistrate should have opened. But what the magistrate has done has written 70 pages. 70 pages. This material, that material, this material, that material, this material, that material. Right. And the law is, at that stage, if the magistrate has found some materials, right, to issue a process or issue a summon, the courts cannot interfere. He has the power. Right. Then it came to, we granted bail and upheld the order. Matter went to court with the trial court. Trial court framed charged, convicted again. High Court said chain of circumstances don't lead to only one hypothesis. Back to square one. Right. So my point is, when the investigation loads it with a lot of materials, high courts have no powers. So unless the investigating authorities are they have the conscience, they have the commitment to have a fair investigation, right? They can do havoc with the entire system. Totally havoc. And particularly the political bosses are interested, they are finished. Absolutely finished. So presently, as the jurisprudence stands, and as the law stands in India, including the Supreme Court judgments, you have seen how difficult it was for Mr. Chidambaram to get bail. If the materials are there, all on record, what would the Supreme Court do? They can't release anybody on bail. Heavy materials. They load the materials. Right, wrong, false, correct, nothing. This has to be done, this has to be done. So therefore, unless the system changes, as you rightly said, the investigation is controlled by magistrates, or it is taken away from the executive, or the political bosses, this cannot be controlled. Or unless the political bosses feel that we have to protect the liberty of the citizens, that is our primary right, that is the primary duty of the state, nothing can happen. Right? The whole thing will go until it ends up in acquittal. It ends up in acquittal, you have a remedy under torts, you have a remedy under legal penal codes. Right? And you also have a remedy for compensation. That's the difficulty. Because the investigating powers are fully with the police. And even British courts have held, I have cited that.
Yes.
Powers of investigation of the police. Right? This is entirely different. Courts cannot assume power of investigation.
Yeah.
Right? Number two, the sanctioning authority is with the government. Right? In case of public officials. Right? That power is independent power. And third, court's power is to find whether the materials collected are true or not. Right? Three different categories. Courts presently cannot, at the investigation stage or when the materials are there, at the cognizance stage or the charge stage or the police report stage, cannot know. They say this material is false, that material false. That is the problem.
Yeah.
The law is also developed in this country like that. So therefore, one suffers totally unless the police investigation culture changes. That thinking changes. This cannot be solved. Or unless you change the law and said investigation will be done under the, like in France, under the supervision of the magistrate, things will change. Otherwise, the police is under a lot of pressure. They are not free from the political issues. This is the problem. This is what you call a major problem in our system.
Yeah.
Unless you get this right, I am trying my best to take out vigilance in Orissa and put it in a locus. If CBI I have seen how CBI functions and that CBC investigation, CBC found inquiry, how CBC functions. Unless the CBI also is put under Lokpal and vigilance is put under Lok Yukta, vigilance and CBI also will not be. So they are under pressure. As Mr. Hemachandra was saying, who is going to protect their career?
Yes.
One officer posted here will be immediately sent to Port Blair.
Yes.
What will he do? Right? They will give up their independent and fair investigation. Therefore, human beings, they are not, unless they are very strong, police, whoever is doing a duty, even judges, nothing can happen. Thank you.
Sir, thank you very much, sir. Thank you very much for that intervention. I totally agree with you, sir. And I think that's the culture that I was referring to, that there is a criminal, across the board, there is a culture that needs to change. And as far as this particular issue is concerned, I think it emanates from an attitude that sometimes you have to go outside the law in order to protect the larger interest and so on. So that culture has to be fought. But I was wondering, sir, whether we could not, following on Professor Mrinal Satish's intervention also, we could not think of conceptually, legally, sir, separating an offense under, say, 211 of IPC.
No, yes, very fine, very educated. These provisions are there, but nobody is taking resort to.
Correct, sir. So if we say, look, a magistrate need not decide whether materials before him in a case are false or not, but you file a separate complaint under 182 or 211 saying I'm being framed and 182, 211 are being violated. And that complaint is separately processed by the magistrate. And how the two will link together is a separate issue. Suppose there are 4 charges and only one is fabricated, the trial can go on, remove one and go on with the other 3. But yes, if it's only one charge and the totally fabricated, then that first case will also collapse. But
yes,
I think we want to take the framing issue out of the main case and put it as a separate case under 211 or 182 and then have that processed and examined. And there are some cases, I'm told, sir, by some people that there is clear evidence of fabrication, recorded conversations, so on and so forth. So that kind of material can be presented along with a complaint to magistrate under 211 or 191 or 182, and a new case can be registered against that. And when we get, so that the magistrate can handle separately, he simply has to examine whether any of the officials concerned have engaged in fabrication of evidence and conclude
Professor,
on that.
right. Absolutely
the
right.
main case can go on.
No, Professor,
So I think yes, sir. Yes, sir.
Absolutely right. But the difficulty is, once the accused is acquitted, right, he does not take his actions.
Yeah,
He should immediately file a complaint, right? And if an rich accused is acquitted, he should resort to tort also and claim damages for malicious prosecutions. Nobody does that in our country. Though there are provisions in the IPC and there are provisions of law of torts. Nobody does that.
Exactly right, sir.
They are very happy if they are acquitted. They are very happy. They go home. Thereafter, they don't want to pursue. They have
so this is very right, sir. So the two practical things that I was thinking of is, one, delink the issue of framing from the main case, and secondly, sir, to bring it up front as a threshold issue rather than wait for acquittal. Because very often, sir, the acquittal does not come even with fabricated evidence at the trial, as in your case, sir. The trial court and the high court convicted. You acquitted at the final stage in the highest court of the country. So the acquittal may come at a very late stage. And even if there is a conviction at the first court, it doesn't mean that there is no fabrication. So we need to look at the framing issue separately from the main case. So that is one of the things. The other thing, sir, is we have to somehow find the strength at the bottom of our pyramid, sir, judicial pyramid, at the district court level, judges. And the bar needs to be strengthened, sir. And the prosecutor.
You are right. This is Gita Mittal mentioned about the trial courts. The trial courts are not that sensitive. They have to be sensitized for advocacy of particularly constitutional safeguards. Right? They should be told that you are not judges only in criminal courts or civil courts. You also have to protect the rights and liberties of people as guided by the Constitution. They have to be sensitized.
You had started a lot of reform of trial courts in Madhya Pradesh, and you had also done training for prosecutors and all that. Now, Gina, our young prosecutor, Gina Kumari, said something which sticks in my mind. She said prosecutors should not be instruments of the government. They should not be tools of the government. They should be actually they are officials of the court, and they are bound to uphold the law. So we also need to strengthen the prosecutors. We need to strengthen the bar. And we need to work at the bottom of the pyramid to try to change the culture of the institution, sir. But I think one tactical thing we can do is to conceptually separate the issue of framing from the main case, and then have the framing issue examined. So these are some practical suggestions that have emerged. We started with you. We are now half an hour beyond our expected time. So, sir, may I conclude, sir, or is there anyone else who would like to, any of the panel's honorable judges would like to say anything? Or